My name is Joel Osekeny. Today I'll be moderating the session. Welcome to day 2 of the Insolvency Conference. We shall be having a breadth of discussions today from our panelists, from our discussants who will be Mr. Andrew Munanura from Sewaland Lule. We will have Mr. Deus Mugabe, a partner at Godena, as well, discussing for us today. And we shall have CPA Ronald Mutumba, a partner at Mutumba Associates, giving us a discussion as well. However, to recap, yesterday we had a long discussion, and I hope we learned something from it. And to give a recap, we had a presentation from Mr. Carito, who took us through a rich discussion on interim protection orders for corporate insolvency behind the scenes. We learned a lot of pertinent issues from this discussion, among them being a discussion of schemes of arrangements together with the provisional administration. He took us through sections 234 to 236 of the Companies Act, and then took us through administration, as well as a few highlights to take out from his discussions were that we need to always try to ensure that businesses are rescued. And his point was that business rescue is only for terminally ill companies. He says in order to rescue, we must deal with the root cause of the problem and not just any other issue. Without the root cause, you can't solve a company's issues, or you can't rescue a company. He then took us through where he said that when we're trying to rescue a company, let's try to not make the company get worse. Our plan is to make it better, to improve the company from death. Secondly, we had a discussion from Mr. Abdul Salam, who took us through the impact of insolvency in employment, where he advised us that during insolvency, we need to balance protections and business realities. One of those being that employees' interests should also be factored in during insolvencies. The key thing that stood out from this discussion is that a company undergoing insolvency does not guarantee that employee contracts terminate automatically. Contract termination is not automatic when you're undergoing business rescue. It only applies if we have a case of liquidation and receiverships. The rest is not automatic. He encouraged us to, when it comes to insolvency and business rescue, we should always try to negotiate contracts, renegotiate terms with the employees. If someone gets a high salary, try as much as possible to reduce the figures. If that fails, then we can try to terminate. But the point is always to try and keep the employees working, renegotiate, and try to avoid terminating if it's not the maximum point to do. He also took us through, he says employee rights are always secondary. The creditors come in first, and then employees' rights come second. Then we had a panel discussion from 5 experts, including Donald and Rogers Turasingura, Malvi Chavda, and Okore Kaldu. They took us through opportunities in insolvency practice in the world today. And from their experiences, the opportunities in insolvency exist in areas of asset tracing, white hackers, conflict management, where they encourage use of ADR in insolvency. They also told us to look out for opportunities in cryptocurrencies and digital assets. They advised us to look at payment systems. They told us to look into partnerships as we try to undergo insolvencies. Mr. Kalu, for example, said that insolvency is not a selfish business. We need to always partner. So they encourage partnerships with stakeholders. It could be tech experts, it could be accountants and other lawyers. We should try to partner with people as we undergo the insolvency systems. Also, they advise us to develop capacity, continuously learn to improve our practice as we undergo insolvencies. They advise us to invest in synergies, advise us to continuously learn and undergo training. Also, they advise us to specialize. Insolvency is wide, you can pick out a specialization and go with that. Let's try to avoid being an insolvency practitioner for everything. We're allowed to specialize. They also advise us to explore digital tools. And then Mr. Kaldu particularly said we should learn to change our mindset, that insolvency is not always about debt recovery. So if you never change your mindset, you might fail to innovate when it comes to insolvency. And then today we'll be undergoing another session for day 2, and our first speaker will be Mr. Andrew Munanura. Andrew is a partner from Sevalulule, having practiced for more than 15 years. His main focus is insolvency practice, where he covers insolvency procedures, business structure, and debt recovery and restructure. He also does asset tracing and deals with recoveries litigation. He's an advocate of the High Court with expert experience in that field. He holds a postgraduate diploma from Nottingham Trent University in International Insolvency Law. He will be taking us through navigating insolvency, effective stakeholder management, and successful resolution. Mr. Andrew, we are happy to have you today.
Thank you so much. Good morning.
Yes. Morning. You can take over with the discussion.
Good morning. How are you all? Can imagine you had such a fruitful day yesterday. Today we'll just talk a bit about some things they don't teach us in law school. I will not be quoting a section of the law, and hopefully we'll have a good time together. So, navigating insolvency, effective stakeholder management in successful resolution. So the outline of the presentation is as indicated there. We'll have a brief introduction. We'll look at the essential steps to managing stakeholders. We shall view some principles of stakeholder management, and then we shall address a few common mistakes which we hope that in your practice as an insolvency practitioner you will be able to avoid. So stakeholder management. Primarily a stakeholder, and it's important before you manage to understand. I'm told lawyers, we like definitions. A stakeholder is any party with an interest, financial or otherwise, in a business, and hence has an interest in or the ability to influence the outcome of an insolvent business. And it's critical for us to understand that a stakeholder need not only be someone who has an interest in a business, but there are those who have the ability of influencing the outcome of an insolvent business. So stakeholder management is just a critical part of navigating an insolvent situation. Your ability to manage those who have interests in a company that is insolvent and those who have the ability to influence the outcome. Now, we manage stakeholders because the relationship between stakeholders has very many varying interests, and therefore it is imperative for us to manage those interests to ensure that natural tensions do not disrupt the process. Sometimes certain interests overshadow the process, and you end up having muddy waters as opposed to having a smooth resolution of an insolvent process, whether it's an administration, a receivership, a liquidation. All those processes need us to manage the varying interests, because ultimately the process is more important than the individual interests. Having a common goal is more important than having individual interests. Oops. The main purpose of stakeholder management is to rebuild stakeholder confidence, and that is critical for us to understand that you manage stakeholders because you're building confidence. By the time you get into, unfortunately in the country, in Uganda, by the time you get into an insolvent business or dealing with an insolvent situation, stakeholders have lost confidence in the business. The business is going through a decline. The incumbent management is refusing oftentimes to look at the reality on ground, and stakeholders believe that their position is at risk. And so it is key for us to note that you're not just managing, but you're also engaging those stakeholders so as to guarantee a successful resolution of an insolvent entity or situation. Now, stakeholders fall majorly into two categories, and those categories are those who have vested interest in the entity and then those who affect the outcome. And as you'll note on the illustration, for example, regulators barely have interest in the entity, but they can affect the outcome. Environmental partners such as NEMA, if it is an industry, might affect the outcome, but don't have a vested interest in the entity. The community might more influence the outcome than have an interest in an entity. The same with local authorities, whereas contractors and suppliers will have a vested interest in the entity, as would customers and employees, investors. MPs and the media, as you've known in some instances, don't have a vested interest in the entity, but they can affect the outcome of an insolvent situation. So your ability to know who are your stakeholders in each insolvent situation is paramount. These two are definitely further divided into three categories, namely those who directly are involved, that is management and employees, those who influence decisions such as lenders and workers unions, and those who need to stay informed, just keep them informed, such as regulators. If you're dealing, for example, with a bank, which is most unlikely, but if you're dealing with a bank, Bank of Uganda, you can't ignore Bank of Uganda. You can't ignore IRA, Insurance Regulatory Authority, if you're dealing with an insurance company. If you're dealing with the retirement benefit scheme, you might not avoid UBRA. So regulators are critical to a business, especially in insolvency matters. Even entities such as URA cannot be ignored. So what are the essential steps to managing stakeholders? Since we have a fair understanding of what stakeholder management is, what are the essential steps? Primarily, when we're dealing with stakeholder management and engagement, identifying, analyzing, planning, and engagement are very, very critical. So I think it's more important to identify stakeholders accurately. Really, listing who the stakeholders are when you're dealing with an insolvent situation might be the easiest, but identifying them accurately is critical. Why do you need to identify them accurately? Is because you need to classify them and cluster them. A word of warning: never underestimate the influence of any stakeholder. Even the smallest of stakeholders might be the most important stakeholders. So after you've identified them, we analyze. The analyzing of these stakeholders deals in two aspects. You need to understand their interests, and then you need to classify them in pools. So do they have common interests? Are there any common interests as you analyze the stakeholder? What are the differences for those in a common pool? For example, if you have banks, what are the differences in that common pool? You might have several lenders, but then the problem that you have is you have lenders who are secured and lenders who are not secured. So those will have different and varying interests. So it's important that you know. So your stakeholder groups should be organized according to their influence and impact, in addition to their interests, so that you can develop a tailored engagement strategy for each. After you have identified and analyzed, it's important that you plan. It is said you cannot conquer what you cannot confront what you cannot identify. So in order for you to plan accurately, you must analyze and identify and analyze. After you've identified and analyzed, you come up with a plan, and that plan is twofold. One, that plan deals with how you're going to manage their varying interests. Two, that plan deals with how you're going to engage those different stakeholders. So each step is important. because if you get the identification wrong, you will not analyze accurately. If you can't analyze accurately, you can't plan properly. Therefore, there will be no engagement, and your managing of these stakeholders will be guaranteed to fail. When you engage, you must engage transparently from day one, consistently and with integrity. In order for you, remember I said in the beginning that part of the stakeholder management stock engagement is that you're trying to build confidence. So engagement must be transparent from the get-go. It must be consistent. It must be with integrity. Your word must be your bond. You don't change goalposts. Because remember, you're engaging them not just in meetings, but even individually. So you must ensure that you're building trust. That is your purpose of engagement. So, as you deal with these 4 steps, remember inclusion, alignment, and awareness. Each stakeholder must be included, common interests must be aligned, and ultimately you must align all stakeholders in the end goal, the strategy, and stakeholders must be kept aware at all times. So as I said, ensure that you identify your stakeholders. In identifying your stakeholders, you need to know what documents do you need from these stakeholders, what documents are you looking at. You must analyze their influence and interest. You must manage their expectation. You must take action, and that is a continual process. Some stakeholders, as you engage them and as you manage their expectations, you're going to find that their interests are shifting. So you're going to review and repeat until you get it right. Review and repeat until you get it right. And probably before I go to the next slide, I think it is imperative for us to understand that if you're not going to take action, then your process of managing stakeholders is useless. Because ultimately, while you're managing stakeholders, while you're identifying them, while you're analyzing them and their interests, while you're managing them through a plan that you've come up with, while you're engaging them so that you take action, remember you are building confidence. Ultimately, it is imperative that you build the confidence of each and every one of your stakeholders. Once the stakeholders have lost confidence in you, then you're no longer an effective insolvency practitioner. So if you're not going to take action, then your engagement is useless at the end of the day. So each process must lead to a determined action plan with specific timelines, and your delivery is imperative. Once you have the consensus of the majority of stakeholders, and I believe yesterday they were telling you about the binding vote, the 75%, etc., etc. And I'm not going to that, but your ability to take action that wins the majority is always important for you to understand that you got a successful stakeholder management. You might not please everyone, but at least please the majority. So after you have identified, you've analyzed, you've planned, you've engaged, and you're taking action, these are principles that ought to remain at the forefront of your stakeholder management. 1, communicate. Communicate in a clear, transparent, and consistent way. So your clarity of view and expression is critical to reducing stakeholder anxiety. So your strategy and quality of information that is shared must be of paramount importance. From the beginning, as you start, they must know the avenues you're going to use to communicate. They must know the intervals of those communications, and those must be maintained. If you say you're going to communicate through the newspapers or every Monday, and one day on Friday you choose to communicate to a few of them through WhatsApp, you're going to have a tremendous problem. If you're going to meet pools of stakeholders, let them all be accurately informed and given sufficient time to be available for that meeting. If you're meeting individual stakeholders as you continue to deal with their interests and trying to build consensus, always live there with an agreed position of what is going to be communicated and communicate exactly that. If any information leaks that is not supposed to be leaking, there's going to be a problem, because winning the confidence of that stakeholder, and sometimes who might be the most important stakeholder, is going to be a problem. So first, communicate clearly, transparently, and consistently at all times. Number 2, consult early and often. So consultations must be made regularly. I was hearing the recap of yesterday, and part of the recap was synergies. So don't only consult your stakeholders, also consult fellow professionals, consult them early, bounce off ideas, try to see if where you're heading is probably not seeing some risk, and they might be able to open your eyes to them. But early and regular consultations are essential to delivering a solution that is acceptable to most of the stakeholders. So keep the stakeholders engaged as you consult them, as you engage them regularly and often. If, for example, if you're going to take a position on behalf of a stakeholder, please consult them. Consult them. Don't just take a position, then you try to force them it down their throat. Consult them. Consult them. So that is very, very critical for you to consult. So manage information flow. Whereas open communication is necessary, you don't have to be reckless and rush, because you have to be open. Balance candor and about facts with discretion. Don't lose sight of the stakeholder aspirations and weakening negotiation position during disclosure. You might disclose a fact that weakens a negotiation position of, for example, of a lender, and that can be frustrating. Or you might weaken the negotiating position of the entity that is in trouble. So as you even disclose information, always be aware of interests and the positions. If, say, for example, a bank is willing to give a discount, and they say we can give a discount up to 70% of interest, don't start with communicating to the borrower and saying the bank is willing to discount up to 70%. Yet actually they began from a lower percentage, they would be able to get better value. So you must be able to carefully disclose. A bank, for example, might have security, but there's a problem with the security. It is not for you to disclose that fact, because it might ultimately affect their position. So open communication, but don't be rash and reckless. Don't be rash and reckless. Manage perceptions and realities. Sorry, that should have come before. So dealing with facts is key. As you know, in your dealing with insolvencies, even just recoveries, you call a debtor, and the debtor comes up with all theories as to why they have failed to pay. So part of your role is to always keep the focus on the facts. There is a debt, there is an obligation, we need to deal with rescuing the company. So you need to manage perceptions and realities. Sort out the junk and deal with the facts. And I think as you've engaged with insolvencies, you must know that the greater problem is perceptions. They will tell you about why someone in the bank is witch hunting them, wants to buy their property, when in reality their problem is they have a debt. They are not dealing with a real problem. They're blind, and they've been having poor management, poor financial controls, and those are what you should be looking at in dealing with a specific insolvency issue. Managing people. Truth is, there is a person behind this company. There is a person in the bank. So it is managing people. Therefore, your relationships are key. Your relationships are key. So developing these relationships across the board increases trust. You're not there to simply say, I don't care. You're there actually to ensure that you put in place relationships that matter. Where there is trust, people work together more easily and effectively. Investing effort, therefore, in identifying and building stakeholder relationships can increase confidence, minimize uncertainty, and speed problem solving and decision making. And that's your ultimate goal. That's your ultimate goal. Your ultimate goal is that you're able to build trust, because when you build trust, things happen. Some of those bottlenecks are easily open, right? They're easily removed. Some of the clogs in the system they're removed, and therefore water it flows easily. Solutions are obtained, problems are resolved, uncertainty is removed, confidence is increased, and decisions are made. And ultimately, you can end up rescuing a company that is in a problem, or dealing with a person who is going through bankruptcy in a better way, without necessarily destroying reputation. If you're dealing with a company that is dealing with product, you've got to maintain market share and market value. Therefore, you need to build essential relationships that help you keep that market share or improve the market share. If you're dealing with a consumer good, for example, food, building the market's confidence is critical. So managing people and relationships is key for you to improve the stakeholder management and the solution at the end of the day. 6, please negotiate effectively. Key to negotiating is listening. Your role is not to hear your voice, your role is to listen. Listen to each stakeholder and make them feel heard. So it's imperative that you listen to them. When you listen to them, please spend time in that room, getting to hear their interests, getting to listen to their issues, getting to listen to their circumstances. It is imperative that you do, because if you don't listen, you're not able to control the narrative, you're not able to come up with a solution that is effective and important to each and every stakeholder that you are dealing with. So, listening is very, very important. Risk, manage risk. It is important that we plan, and the first thing in planning about risk is to anticipate. Your ability to anticipate hazards, your ability to anticipate risks that you're going to come up with is important. Therefore, risk management requires you to take time. Some insolvency practitioners actually will have a fully fledged risk management team whose role is to do just that, right? Use foresight to anticipate hazards and take simple and timely actions with stakeholders can significantly improve the results. So as you identify, take simple and timely actions. Have a team if you must, in order to anticipate risk. You might not be able to actually identify all of them. Some of them will come up like hazards that we get in this country, but your ability to anticipate those risks is imperative. So have a team. Have a team. If you're dealing with an entity that deals with very many customers, for example, a telecom company, one of the risks is loss of market share, losing customers, right? And you can see that happening. If you're not able to give quality products, you are going to have a problem. If you're producing vehicles, you have got to manage risk. Are you still producing a good car? Your phones, if you're dealing with a phone company, is the product still liked on the market? How do you maintain a market share? What new innovation are you able to bring to maintain market share? And you cannot manage risk if you're not listening, because in listening you get to understand some of the risks that are likely to pop up. Number 8, compromise. Compromise is key. So seeking the common good of all, or at least the majority of stakeholders in most instances is important. There are certain situations that you can't compromise on. For example, if you're trying to build stakeholder confidence, you might have to fire a few people. And those are things you might not compromise on, but ultimately you need to compromise them. Stakeholders must know that they will need to compromise. You can't just remain on your fence and expect there to be a solution that is beneficial to all stakeholders. So adapt your plan to meet the needs of stakeholders. Along the way, even as you plan, you need to keep changing your plan. The general view of the plan might not change, but the parts that fit into that plan might have to change along the way. So in compromise, there is compromising with stakeholders, compromising in your stance as an insolvency practitioner, but also ensuring that stakeholders can compromise, because the only way to shorten the distance between stakeholders is to actually have them move towards one another, and that is why compromise is key. Ask questions. If you're in doubt, ask questions. Consult. Trust your team. Collaborate. Have synergies. No one knows it all. Make a few phone calls. Meet people. Consult with your stakeholders. Ask them questions, because the solution usually is within them. How to move forward is by them. It's them who control the narrative. So in case of doubt, please always ask. And then after that, after you've done those, one thing you need to always do is plan. You must have a conscious and measured approach to stakeholder engagement. It's essential, and it's therefore encouraged. Invest in carefully planning before engaging stakeholders. Don't shoot in the dark. Have a specific target. Even who do you engage first is important. Yeah, you might engage who you consider to be the most important, and that will affect your result. Yet they're the least important. So how you engage is important, and that all comes with careful planning. So back to identifying, analyzing, planning, and engaging. You must do those within the confines of these principles. You must speak clearly. You must consult often. You must manage perceptions. Information flow is important. Managing people is critical. Listening is a virtue that all of us must have. You must manage risk at all times, lead to compromises, ask questions, and plan effectively. Now, the final limb of stakeholder management is common mistakes. It is said that when we plan, when you learn from your mistakes, but certain mistakes are worth not attempting to learn from. Because in insolvencies, as you are aware, one simple decision can change the course of a business. A business that starts as merely as an administration can end up in an insolvency because of a mistake that you made. Some mistakes are forgivable, some can actually be career defining and might end up messing the rest of your career as an insolvency practitioner. So these are some of the common mistakes. Identifying stakeholders improperly. Planning is impossible without this key step. If you're not going to identify your stakeholders correctly, the execution of an insolvency is as good as dead. It might look a very small task for you to do, but please don't risk it. For example, you might be dealing with a consumer good, a company that produces consumer goods. They deal with, say, crisps, etc. Food. It's a hotel, and probably the workers' union is the most important stakeholder for that entity. But for you, employees are not important, and therefore you think that the most important is the association for hotels in the country. Or it might be an entity that actually has products on the shelf, and you think the most important is the supermarkets, yet the most important is UNBS. So you really need to be careful in identifying who your stakeholders are. Identifying them wrongly, you cluster them wrongly, you will end up having a bad plan, which is must be avoided at all times when you're dealing with insolvency practice. Failure to understand the expectations, needs, and concerns. Now, if you can't understand their expectations, how do you expect to engage them? You can't negotiate effectively if you don't understand expectations, needs, and concerns. You can't formulate a plan if you cannot understand these plans. So don't make this mistake, because you'll end up having a crisis on your hand simply because you do not understand expectations, needs, and concerns. Seek to understand the role of each stakeholder, how they can affect and will be affected by the insolvency proceeding. It's important. But if you fail to do, which the majority of insolvency that go bad is because they did not understand expectations, needs, and concerns. So please identify them. Now, it's important that you understand how the common mistakes keep growing. You fail to identify, you fail to understand, and therefore you fail to manage their power and interests. Now, it's important to note that as an insolvency practitioner, you're not there to babysit emotions, but it's important that you never lose sight of interests and the power of a stakeholder. Because remember, they are affected and can affect the insolvency proceeding. So don't underestimate or overestimate a stakeholder's influence or impact on a process. You might have a shareholder has 2%. You ignore that shareholder because you don't think they are necessary. Yet their greater impact is they know people. They can have doors opened. So please, underestimating or overestimating can lead to disastrous results. Don't make the big mistake of engaging or managing all stakeholders in the same manner. Not to suggest that you should underrate any stakeholder. It's important that all stakeholders are considered, all stakeholders are honored, respected, but do not underestimate any one of them or overestimate the role of any one of them. I mean, if you look at the NACMAT situation, the NACMAT situation is that part of the problem was stakeholder management. Some of the least or unconsidered stakeholders affected the process of that insolvency proceeding, and they are none other than the court bailiffs. They were touching everything left, right, and center, right? And in order for you to control the narrative as it's self-control, if you can't plan properly, if people are touching, so never underestimate power and interest of an entity. I mean, part of your stakeholders, an important stakeholder is the court. You might ignore the court or go into a quarrel with the court and end up having a problem, not being able to get a moratorium, for example. So do not take these risks. It's not worth it. Failure to keep stakeholders updated. I mean, even in your day-to-day work, when you're engaging clients, you realize that if you don't keep a client updated just of simple things, what happened in court, a court date, you get a big problem on your hand. So from the beginning, you must engage them on a consistent basis. You must advise them of the progress. You must advise them. You must keep them updated. If stakeholders are not kept updated, you have a very, very big problem. So too much, too little, too promotional, too simplistic information is dangerous. Information not disseminated in a way that will reach the intended audience is disastrous. So it's not just about update, but it's about what and how you deliver these updates. So failure to keep them updated can be a problem. And then also failure to identify, assess, and manage stakeholder risks is also a common mistake that should be avoided. I think it's important to understand that there is no small risk in insolvency. Small risks, if ignored, can actually lead to great blunders. You might publish in the papers, for example, but fail to inform banks that you're now the insolvency practitioner in control of this entity, and that can lead to great loss to the value of the estate. Remember, insolvency proceeding is about two things: building trust and maintaining value for stakeholders. If you're not building trust and maintaining value for stakeholders, you're going to make blunders. So you must ensure that you regularly monitor risks. If you need a team specifically for that, do that. A team that scans social media, a team that scans newspapers, a team that looks out for risks. What is happening in the market? What are competitors doing? How is this situation being used by competitors? Which competitor is going to best benefit from this insolvency proceeding? They might not be interested in the entity necessarily, but they can affect the outcome of that insolvency proceeding. Remember, your name is on the line, right? Your name is on the line. So always identify, monitor them, look, where is this going? Where is this risk? If a risk is from a specific stakeholder, how are you keeping the stakeholder engaged? How are they updated on the process of the progress of the proceedings? So don't do this. Don't improperly identify stakeholders. Don't fail to understand the expectations. Don't fail to manage their power and interest. Don't fail to keep them updated, and identifying, assessing, and managing risk. So that's all from me on stakeholder management. In case there are any questions in the chat space or through audio, I'll be happy to take them. But I think before I take the questions, what is important is that stakeholder management cannot be taught, it has to be learned. So until you do it, you'll make a couple of mistakes, but don't make at least the 5. Keep the principles at your forefront. Keep the essential steps at the forefront. Identify, analyze properly, plan, and engage. When you engage, take action. Take action. When you take action, the stakeholders build confidence. You build their confidence, you build their trust. If you maintain the value of an estate, and that is very, very critical. Don't lose sight of that your role there is to build confidence and to build the trust of stakeholders and maintain value, in the estate of the insolvent.
Yes.
Thank you.
Thank you so much, Mr. Andrew, for the rich presentation. Maybe to recap for our viewers, I might have to highlight a few things that picked up from the discussion. And the first one being that under corporate rescue, it's important to identify the stakeholders. And it tells us that the stakeholders are the people who will be involved in the rescue process. It says to identify them, you need to, or to manage them, you need to be able to identify them, analyze, plan, and engage with them with the overall objective to please the majority. It even tells us that when you're trying to manage stakeholders, you must follow some key principles. And some of those are communicate, consult early, manage information flow, manage perceptions and realities, manage information flow, manage the people, negotiate effectively, manage risk and anticipate risk, compromise, and then ask questions. Then finally it says develop a plan. When you have those in check, you will have managed the stakeholders properly. And then it says you should try to avoid common mistakes, which we discussed. And so in our next phase, we'll have to go through a Q&A. If you have any questions, please forward them. Then we ask the speaker. I've so far received 3 questions as I wait for more to come in. And the first one is from Mr. Andrew. When appointed by creditors as liquidators, what do you do if creditors reject you outright? What tips do you give? If you're the liquidator and you have creditors who reject you outright, how do you resolve it? What are your tips? The second question is, how do you engage employees in a receivership? Do you meet them one by one, or do you meet them in a group? There's a hand. Yes. Do you meet them in a group, or do you meet them one by one? What if the number is very big, like 500? How do you handle that? The other question will come after those 2 are answered. We have one in a group coming in, but let's start with those 2.
Thank you. When creditors reject you, you walk away. You can't force yourself there. My view is that you need everyone believing that you're able to find a solution. If there is little or no faith in that, then you're going to have a big problem. So it's imperative that if you have been appointed as a receiver, a liquidator, whatever it is, and the creditors at the first meeting say, we don't want you to be the share, you go through the process of withdrawing from that, because creditors are one of the most critical stakeholders. If you don't have them on board, it doesn't help. Employee engagements, I have 2 suggestions on employee engagements. First and foremost, I would engage them as a group, and the primary role of engaging with them as a group at the very beginning is to do one thing, that is to get them to appoint representatives, people you will engage with consistently, and there shouldn't be many, right? So if you have 500 employees, let them appoint representatives who you can engage, who you can disseminate information through, but at some point you need to consistently have those engagements with those employees. They need to feel valued. At some point, the problem with having large numbers of employees is that they are one against the other. So you reduce the group, get a small number of those employees, 4, 3, 4, 5. Let those be part of the team you'll be meeting. More or less, they are proxies, because you can't. It's hard to manage 500 people. There are too many emotions involved. So my advice is that first meeting, meet them as a group. You want to build confidence. In that group, you'll get to see the vocal ones, you get to identify, but then you get to tell them, look, I need us to identify people who will represent your common. If they have a union, then engage them through their union. Don't engage them individually as employees, engage through the union. Because unions are very, very powerful stakeholders. Don't ignore them.
Thank you so much, Andrew. We have 2 more questions. One of them is from the Zoom, from online. We have Vincent Bitature. What's your question? Vincent, you have the mic. Is Vincent on? Vincent, are you on? Maybe he is preparing his question.
No, yes, please.
Yes.
I wanted the presentation very large a bit.
Thank you so much. We've noted that.
Okay, I think the presentation is going to be shared by ULS. My apologies about some of the small print. Sorry, my sincere apologies, but yeah, they'll be shared.
And then maybe the last question. Thank you, Vincent. The last question is it possible to bridge the gap between creditors and debtors where communication has failed between them? Is it possible to bridge the gap between creditors and debtors where communication has failed between them?
Yes, you can bridge the gap, and you bridge the gap through building of trust. So for example, if you're dealing with a scenario, usually creditors are not talking to debtors because debtors are not making payments. So when you get in and payments start coming in, then you're building trust. I've told people often, the debtors I usually meet, that the love language of creditors is money. So you must ensure that money comes in. If a debtor today say, I pursue a debtor, puts in a repayment plan, creditor says, we've given this guy an opportunity and they failed to do it, I tell them, look, that's fine. He has given me this proposal. Let me have a look at it. Let me follow through. When the debtor usually starts making payments, even if they said every month they would be paying $10,000, and the first month they pay 10, second month they pay 10, third month they pay 8, they've already started building trust. Whereas there's been a blip, but they've built trust. So it's building trust is a longer process, but it can be done. And some entities recover, they paid bank debts, and they even go back to those creditors and they give them money again. So you can build trust. It's a long process, but you can.
Thank you so much, Mr. Andrew. We appreciate your time with us.
Thank you.
Have a good day.
Thank
We'll go to the next session, then we have another speaker coming. Thank you so much. Yes, the next speaker for the next session is Mr. Deus Mugabe. We shall be going to the next session where he's presenting an interesting topic as well. Mr. Mugabe Deus is a partner at Godena Advocates, a law firm in Kampala. He specializes in international tax advisory, transfer pricing, domestic tax advisory, tax litigation and ADR, tax planning and restructuring. He also handles mergers and acquisition transactions that involve taxations. He also handles corporate finance and insolvency. Deus has acted as a research assistant to Professor Bachibinga, Dr. Julia Kangave, and Mr. Dan Ngavirano on the ICTD working paper. The paper was What Explains the Recent Calls for Reinstatement of a Tax Considered Opinion and a Tax Considered Unpopular, an analysis of graduated tax in Uganda, ICTD working paper 79. He's also a researcher to Professor Bachibinga. He is a sole author of a book, Mugabe on Insolvency Law in Uganda. It's a very new book. I think it's available on the market now. The book was released last year, and it reviews the Insolvency Act in light of the amendments. He's also an editor-in-chief of the Makerere International Law Journal, 2017 edition. Mr. Deus holds an LLM in tax law with a distinction from Queen's Mary University of London. He is a Bachelor of Laws degree holder from Makerere and a postgraduate diploma from LDC. He also holds a diploma in taxation and revenue administration from the East African Tax School. Mr. Deus will be taking us through the topic, which is the second presentation today, navigating the intersection of insolvency and taxation, strategies for financial stability and compliance. Mr. Deus Mugabe, thank you for coming. We are ready to receive the rich wisdom from you. Please take over.
You're welcome. Good morning, everyone, and to our listeners. Thank you for joining in. I'm going to discuss the topic highlighted by my friend here. We'll be talking about navigating insolvency and taxation strategies for financial stability and compliance. As introduced, I am Deus Mugabe. I hold a Master's of Laws in Taxation from Queen Mary University of London. With a distinction, I hold a postgraduate diploma in Revenue and Taxation from the East African School of Tax. I also graduated from the Law Development Center. I have a Bachelor of Laws from Makerere School of Law. I'm currently a partner at Godena Associates, Vice Chairperson of the Insolvency Law Cluster, the Uganda Law Society, and as stated by my friend and colleague, I am also an author of a textbook titled Mugabe on Insolvency Law in Uganda. I will start off by taking us through the intersection of taxation and insolvency. These are two interesting regimes. We could add, in a way, complicated regimes, but it is possible in our practice to consider taxation and disregard anything to do with insolvency law. And it is also possible for an insolvency practitioner to enjoy their practice area without considering taxation. But this is wrong, as we will see in this presentation. It is always important that anyone engaged in designing a tax registration considers the impact of the taxation regime or legislation to the enterprises, businesses. A poorly drafted tax regime can easily send many companies to insolvency and liquidation, and for individuals to bankruptcy, as we shall see later. Very quickly, the government has powers vested in it by the Constitution to collect a portion of our income. Any citizen who derives income in Uganda, and for that matter, a non-resident person who earns income sourced from Uganda is also required to pay taxes. The desire is that these taxes should be used to provide public services to the citizens. It's a duty under the Constitution of the Republic of Uganda to pay taxes. Now, government, of course, has passed several laws to impose various tax liabilities and obligations on citizens. As I said, in cases where you have a poorly drafted tax legislation, this can easily lead citizens and companies in financial disasters. So you want to have a tax regime that is designed that considers the practical business aspects of the people on the ground. Now, you can also use a tax regime to enable companies survive difficult economic times. As we saw during the COVID pandemic, the government gave Ugandans interesting waivers, and this was a very helpful step. So you can use tax in that sense to enable businesses. The tax law, for example, recognizes that businesses can be operated, and we might inadvertently find ourselves operating in losses. But in any case, when you're starting up a business, and a business that requires heavy capital investments at the initial level, you find yourself in a situation where you will be operating in losses for a foreseeable future. So the government and the tax regimes always recognize this and provide the taxpayers with grant us permission to deduct losses that have been incurred in generating our income. Also, the tax laws also enable us to restructure businesses without suffering major tax liabilities. In many cases, you restructure and go away without paying any taxes. Otherwise, if they don't do that, if every restructuring resulted into disposal of assets, we would find ourselves in major tax problems. So it therefore is important that a good insolvency practitioner understands the tax regime and how the tax regime affects insolvency, and the other way around. If you're a tax practitioner, you need to know how this can be, these two phenomena cross paths. This presentation therefore seeks to make sure we highlight the importance of complying with tax laws, and thereby arriving at financial strategies that can help enterprises that are in financial distress, or using tax regimes to avoid situations where we find ourselves in financial problems. Talking about tax now, what is tax? Now, a nice place to start from when discussing what taxation is understanding what taxes are. Okuja says that taxes are a compulsory payment or financial charge imposed by government to raise funds for the provision of direct or indirect public goods, services and or benefits. When you look at this definition, it tells us that taxes are compulsory. It tells us that they are imposed by the legislature, that they are also aimed at raising revenue to be used for the delivery of public services and goods. But a helpful definition of what the term taxation means is provided by Professor Bachibinga in his book Revenue Law in Uganda, where he says that taxation is defined as the imposition of duties for the raising of revenue. It is a device used by government to extract money or valuables from people and organizations by the use of law. All forms of taxation are imposed by Parliament. Taxation is a creature of statute. Taxation, therefore, encompasses every charge or burden imposed by a sovereign upon persons.
I think it's on,
Taxation, therefore, encompasses every charge or burden imposed by a sovereign upon persons and property rights for the use and support of government, thereby enabling it to support its functions and activities. This definition tells us who imposes taxes, and an important part of taxation is that, and which is born in our constitution, is that you must have a law before you collect the tax. So URA is only allowed to collect part of our revenues if it can point to a particular law. A taxation must be passed by Parliament. And the purpose of it, of course, is that you would get public goods and services if you pay your taxes, which a lot of research shows that when citizens are comfortable in assuming that their tax contributions are used to provide public services, then their compliance, voluntary compliance to taxes, is high. In the Ugandan context, that might be a discussion for a full day. Now, if we go on to define what insolvency means, when you look at the Insolvency Act, it does not define the term insolvency. You don't get any helpful definition there. The Insolvency Act tells us that insolvency includes bankruptcy. So it doesn't really help us define it at all. But renowned scholars like Professor Roy Good in his book Principles on Corporate Insolvency Law define the term insolvency to mean simply inability to pay debts. Now, the phrase inability to pay debts must be given its technical interpretation. It's not every time that you demand someone and you go to them and say, I need you to pay my money. Then they are insolvent if they don't have it at that particular time. There are processes that the law puts in place to protect people from flimsy and questionable debts. So Section 3 of the Insolvency Act lays down what it means when we say inability to pay debts. You need to have failed to comply with the statutory demand, for example. There should be a failure to comply with the judgment, an order arising from a judgment. So you are a judgment debt and failed to comply with the order of court, and other methods that can prove that someone has failed to comply with the legal framework in respect to payment of debts. So when we say insolvency means inability to pay debts, we are not talking about this term in a loose sense. It is supposed to be failed to pay debts in accordance with the law, not in accordance with what the creditors think is meant by that term. Then the law, the insolvency legal regime. To get a logical answer to this statement, we need to identify, for example, the objective of insolvency law. Now, insolvency law is designed to maximize the returns of creditors. 2, it is designed to establish a fair and equitable system for ranking of claims and the distribution of the assets amongst these creditors. Now, especially in foreign countries, it is also designed to provide a mechanism by which the causes of failure can be identified, and then those who are guilty of the mismanagement be brought to book. And where appropriate, these particular people who drive these companies into these situations be deprived of the right to be involved in the management of other companies. That's summarized by Professor Roy Good in his book on principles of corporate insolvency law. There are other objectives which Nelson Nerima, in his book Uganda Insolvency Law Handbook, states, extracted of course from the report of the Insolvency Law Review Committee. The Insolvency Law Committee. These include an objective of insolvency being to preserve the estate of the data, such that it allows for equitable distribution of the assets to the creditors. The aim of this, of course, is to prevent premature dismemberment of the data's assets by individual creditor actions to collect individual debts. In short, the aim is that once we descend into liquidation, or receivership, or bankruptcy, and for that matter any insolvency proceeding, then then collectivism sets in, and individual creditors, including URA, should not have the right to disorganize the estate at that level. Also, insolvency is designed to provide for timely, efficient, and impartial resolution of insolvency, with the view of avoiding undue disruption to the business activities of the debtor, and to minimize the cost of the proceedings, the insolvency proceedings. That leads us to the next point, which relates to what I've said previously, which is that insolvency law and insolvency proceedings, for that matter, favor collective actions of the creditors. And thus, insolvency proceedings, once the insolvency proceedings have commenced, individual creditors, and this includes URA, lose their right to enforce collection measures against the debtor. The creditor of whatever category must line up with other creditors, so that collectively we can then decide who takes what from what assets. And so that's a major part of insolvency law, and it's protected by very many principles that underlie insolvency legal regime. For example, the anti-deprivation rule, very well articulated in Belmont Park Investments Pty Limited versus BNY Corporate Trustee Services Limited. I always implore anyone interested in understanding this area of law to look at that lengthy and yet complicated case, but the complication is worth going through. Also, there is the pari passu rule. Now, reduced to its logical conclusion, the anti-deprivation rule posits that if a company has descended into insolvency proceedings, its assets, the data should not reduce the pool of assets by entering into contracts that say that the moment you enter into liquidation or insolvency, then this asset will go to another person. The pari passu rule posits that once we go in receivership, in insolvency proceedings, every creditors of the same ranking should benefit at equal level, in equal portion. What that means is when you get these two principles, they assuming the estate of the the data was to be treated as a pie, could call it a cake. The anti-deprivation rule is designed to preserve reducing the size of that cake just immediately before the company descends into liquidation. So the cake should remain the cake that was in the hands of the company before we descended into insolvency. Now the pari passu rule then comes in to determine, now that we have a cake that has been preserved by the anti-deprivation rule, how will we divide the cake? And the rule says we shall split in equivalent terms if we are at the same ranking. Now, claims and priorities of claims. That's an integral part of the insolvency laws, and insolvency law is most important in regulating who may claim against the debtor's estate, which claim should be repaid from the debtor's assets, and the priority that must be followed when repaying these claims. There is a discussion of this in paragraph 2.3 of my textbook, and that's a very integral part and leads into our discussion nicely, because we then have to appreciate what's the nature of the claim that URA holds against the assets of the debtor, and two, if it had those claims in terms of ranking, where do they sit? Okay, there are layers. There are layers in terms of the assets that are available and how they will be distributed. We have secured creditors, we have unsecured creditors, we have some debts that are treated as preferential debts, and it's therefore important that anyone interested in insolvency law understands that part. And in addition to understanding that part, it's also critical to understand where a particular class of creditors sit. And particularly for our discussion today, where does URA fall in this ranking? Before we go to where URA sits, we'll talk about the types of creditors. As said, we have unsecured creditors. This term is not defined under the Insolvency Act, but generally it can be understood to mean a creditor who does not have a charge over the property of the debtor. So URA, though a potential creditor of any business, is generally an unsecured creditor. Now, but in respect of one tax head, which is withholding tax, URA enjoys preferential status, as its claim for withholding tax is treated as a preferential debt under insolvency law. Now, secured creditors, these are defined, thankfully, and the Insolvency Act tells us that a secured creditor means a creditor who holds, in respect of a debt or obligation, a charge over property. Secured creditors, of course, now enjoy clear, certain protection following the repeal of Section 12, subsection 2 of the Insolvency Act in 2022. This was one of the most chaotic areas of insolvency law, to the extent that the priority that would otherwise be granted to secured creditors was thrown into confusion by a section that made their claims subject to some of the preferential debts, but luckily that was taken out. Insolvency Act clauses unpaid taxes and specifically withholding taxes, preferential status, and that will be the details of that will follow. Now, preferential debts are listed in 3 successive provisions, and they must be paid in the order of priority in which they are listed in that section. Now, the sections that list these preferential debts are Section 12.4, Section 12.5, and for purposes of today, the third category sits in Section 12.6. And it says, the amount of any tax withheld and not paid over to Uganda Revenue Authority for 12 months prior to the commencement of insolvency proceedings are preferential debts. So we have a category, a third category of preferential debts, which specifically provides for this issue. Now, why is it important that debts are treated as preferential debts? Now, the liquidator or trustee is mandated to apply the assets to the preferential debts first before making a distribution to unsecured creditors. Now, as the name suggests, preferential debts must, as a general rule, be paid in priority to other debts. Of course, the exception to this being that preferential debts are subject to provisions in relation to claims by secured creditors. Now, specific to the tax issue, the question is, which taxes enjoy preferential treatment? As a creditor, URA is not entitled to claim every tax not paid by the debtor at this stage and claim that they are preferential creditors. URA only enjoys preferential status in respect of withholding tax. Now, for URA to be considered as a creditor whose debt is preferential, the taxpayer must have withheld the tax, one, not remitted the same to URA, and then that tax liability has not been paid for a period of 1 year. So we work backwards from the time you descend into insolvency for a period of 1 year, and then calculate the amount of withholding tax that has not been remitted for that purpose. Now, for tax purposes, then we need to understand that a withholding tax is not a tax liability that is primarily the responsibility of the debtor in this context. Because everyone who withholds tax is required to remit the same to URA in the next month. And in this way, the withheld tax is the tax liability of the person who made the initial payment, who made the payment to who you make a payment to. So it's their creditable tax. It's not your tax liability. So you shouldn't be withholding it. So to not withhold it is merely a problem that is self-imposed. And I think for me, the policy reasoning behind this enactment and the limitation to withholding tax can be justified, because you just held taxes and refused to pay them. Now, there is a myth that outstanding tax liabilities, including income tax, including VAT, and among others, before the debtor descends into insolvency, are preferential debts. This is not correct, of course, as can be seen from the wording of the section. The section is clear and it says we have to look at we only have to look at the withheld tax, or the tax that was withheld and not paid over to the URA. Now, we've talked about the point that generally URA is an unsecured creditor and its withholding tax is a preferential debt. But arguably, the regime provides that in some instances, URA can be treated as a secured creditor. And this is because of the provisions of Section 34. Because URA is enabled by law to create a charge over immovable property owned by a taxpayer. And the wording of the law says that once this charge has been put on the property, immovable property of the debtor, then such charge assumes for legal purposes the same characteristics as a legal charge or mortgage on on property. This is borne out in section 34 of the Tax Procedure Code Act. It provides in particular that if a taxpayer who is the owner of land or a building in Uganda does not pay tax by the due date, then the commissioner may, by a notice in writing to the registrar of titles, direct the registrar that the land or building in the notice the subject of security for unpaid tax. Now, a charge over immovable property in the favor of URA, in accordance with the above section, is accorded the same legal status as that charge arrived at after a negotiation that leads to normal borrowing. Now, the sections provide that upon receipt of the notice, the registrar shall, without a fee, register the directive as if it were an instrument of mortgage or charge on land or building, and that registration, subject to any prior mortgage or charge, operates in all respects as a legal mortgage or charge on that land or building to secure the amount of the unpaid tax. What this means is that if before you descend into insolvency, URA imposes a charge over your property, it can properly fall within what we call a secured creditor and might enjoy the treatment as the third subsection of section 34 says. Luckily for taxpayers, I think in practice URA is always lenient and doesn't invoke this charge. But if it were to do that, then the scales would almost of the times change. Now, we can then talk about exploiting insolvency procedures to avoid or evade taxes. As I said, insolvency in its current form is designed to support business restructuring, business rescue, and at once to facilitate an orderly winding up of the company. Now, insolvency proceedings can, however, be misused to avoid or evade taxes. Note that URA, like any other creditor, in respect of taxes that are not as a result of a distressed company failing to comply to its duties as a withholding agent, is like any other creditor. On the one hand, a tax liability can be big, and tax liabilities, I should mention this, are debts to the government, can force a company into, or business or individual into insolvency, because this particular debt can easily be a huge debt. And to put this in context, if you are an individual whose income is above 120 million a year, the government is interested in your revenue up to 40%. If you're a company, the government is interested up to the extent of 30%. So you have a huge creditor that unfortunately you can't do away with. Now, if government decides to enforce its collection measures stringently, it's possible that alone can force a company into a business into insolvency. So on the other extreme end, there can be a situation where the company owners or managers decide to extract the value from the company. They fail or refuse to pay the applicable taxes and then liquidate the company or business for that matter. That way they have avoided or evaded taxes. Now, the later issue, the situation, that is where the company owners decided to extract value, refuse to pay the taxes, wind up the company, may lead to something called technically as phonexing or phonexism. Now, phonexing means the practice of running up the tax liabilities of a company. Then you avoid paying the taxes by making the company insolvent and setting up a new company to carry out the same business again. So you gather a tax liability of 1 billion, you don't pay it, wind up the company. and start the same business using another company. Now, many countries, of course, fight this problem called flexing. A good example is the United Kingdom and Australia. The United Kingdom, since 2018, has been active in pursuing this practice as an appalling one. An example of flexism is that you have Mr. A and Mrs. K and Mrs. V as shareholders of AKV Limited, a company that was registered in 2017. Now, AKV Limited manufactures mint shower gel, a very popular product amongst urban middle class. Now, AKV Limited has not been filing returns nor paying its taxes. In 2020, 3 years later, URA commenced an audit against AKV Limited. Now, AKV Limited in 2021 commenced liquidation processes. The liquidation processes were completed in 2022. In the case of the liquidation, the assets of AKV Limited, in the course of the liquidation, the assets of AKV Limited were purchased by a company called Mint Limited. Now, Mint Limited is a company that was incorporated in 2022, with its shareholders being the same people that were the shareholders of AKV Limited. Now, Mint Limited starts production of mint shower gel, again, the same product that was produced by AKV Limited. Mint Limited operates in the same premises that were used by AKV Limited. It also has the same suppliers. It also engages the same employees as the liquidated AKV Limited. Now, this is the phenomenon called phonexism. Now, what reach this logical conclusion? Phonexism will help the shareholders to transfer the business to a new company without transferring the debt. So the debt dies in the older company, in our example, AKV Limited, during the course of the liquidation. But the business itself is carried on to a new company. Now, that is that's evading taxes. And that's why many countries set out to fight the problem. Now, taxation, as we have said, can be looked at one way as an evil thing, to the extent that it can drive you to insolvency. But then taxation can also be used as a tool to excuse or avoid insolvency proceedings, or enable companies and businesses thrive in harsh economic times, as I said at the very start. Now, one of the important things is the way taxation treats losses and losses carried forward. As we must know now, when a company is operating in losses, it's very easy for it to run into insolvency proceedings. Now, a taxation regime that doesn't recognize that fact, therefore, would lead to more insolvency cases than is necessary. What that means is it is important, therefore, that we appreciate that the tax regime in Uganda, at least, allows us to expense our losses in some circumstances when we are computing our tax liabilities. Thus, the government has allowed losses incurred by a taxpayer to be allowable deductions. This is in terms of the income tax liabilities. Now, the Act in that regard provides that there shall be allowed as a deduction all expenditures and losses incurred by the person during the year of income, to the extent to which the expenditures or losses were incurred in the production of income included in the gross income. This, it goes without saying, enables companies to survive the harshness of the opposite circumstance, which is that losses, if incurred, would never be recognized in the computation of taxes. But crucially also is the fact that taxpayers operating in losses, where the total amount of income included in your chargeable income is less than the amount of your allowable deductions, are allowed to carry forward the losses. There is currently a debate in, not the debate, the bill was passed, which will of course alter the total enjoyment of this right. But as currently stated, where, and even if they pass the amendment, what this tells us is that the law is recognizing circumstances where a company is actually operating in losses, and it is saying that we will allow you to carry forward the losses. Under the proposed changes, this will have an end. As currently in the laws, of course, you would be able to carry forward your losses until you utilize them. Now there is a cap up to how long you can do this, and in any case, they will now be giving you 50%. Now, at its simplest, and for purpose of understanding what the losses carried forward issue means, can be solved in this simple example, which is that you have company A, which has a total income of 100 million as income included in its chargeable income for the financial year 2020-2021. Now, in the same year, company A has allowable deductions of 150 million. Now, company A has an assessed loss of 50 million, the difference between your allowable deductions and your total income. Now, in its current form, the law allows company a deduction of 50 million in the next financial year 2021-2022. If, in fact, this was not recognized by tax laws, company A would find itself in insolvency much sooner than it expected. However, for insolvency purposes, and this is a clause that we can say is a clause of questionable importance, the reverse of using taxes to enable companies to run is that the amount of an assessed loss carried forward under Section 38 for a taxpayer shall be reduced by the amount or value of any benefit to the taxpayer from a concession granted by or a compromise made with the taxpayer's creditors in the course of insolvency, whereby the taxpayer's liability to those creditors have been extinguished or reduced, provided such liabilities were incurred in the production of income included in the gross income. This subsection 3 of section 38 does not help us when we look at the trend, which is that we need to look at insolvency as a tool for rescuing viable businesses. We must never kill businesses if they are viable. What the tax law is saying is that, and when we say rescuing a business, a taxpayer who's heavily indebted can enter into a compromise, can have a concession with creditors, and that concession might result into a reduction of the total tax liability. What that does mean is that if you had indebtedness of $20 million and the creditors forgive you $10 million, and you had this in your carried forward losses, the tax law is saying that forgiven debt will now be removed from your losses carried forward. Of course, it would serve any business if it was, not removed, so that then tax law would be used as a policy to enable a struggling company to recover much faster than it is now. Then there is the rollover relief, which helps companies that are undergoing reorganization. So if you have a Ugandan company, a resident company, or a group of companies, and they are reorganized, and that reorganization does not result into a significant change in the underlying ownership of the company or group, then the commissioner is allowed to exercise their discretion to permit the resident company involved in the reorganization to treat the organization as not giving rise to disposal of any business asset. Now, why is that an important thing, or realization of any debt? According to Section 18 of the Income Tax Act, when you dispose of an asset or realize, or there is a realization of a debt, then you have earned capital gains that are taxable. So that can be done away with by the commissioner saying, okay, this reorganization, I'm happy to treat it as one that is not arising to that tax liability. The commissioner then can determine that the cost base of the business asset held or business debt undertaken by the resident company after the reorganization, in order to reflect the fact that no disposal or realization is treated as having occurred. Now that is when there is a reorganization, but also there is a benefit provided when there is a liquidation, and then the assets of the in the course of the liquidation are bought by a shareholder resident in Uganda. And that relief works as follows. Where, as part of the liquidation of a resident company, a business asset is transferred to a shareholder, being a resident company, other than an exempt organization, of course, the transferee company, and that being the transfer, and immediately prior to the transfer, the transferee company held 50% or greater interest in the voting power of the liquidated company. Then, the transfer is not treated as a disposal of a business asset by the liquidated company, but is treated as an acquisition of a business asset by the company that acquired the asset. The company that acquires the asset's cost base is equal to the liquidated company's cost base for the asset at the time of transfer. The transfer of the asset is not a dividend, and no gain or loss is taken into account on the cancellation of the transferee shares in the liquidated company. These are contained in section 77 of the Income Tax Act. Now, there is also, the tax law also enables us to reorganize our businesses by exempting from VAT a transfer of a business where that transfer can fall within a category of a transfer of business as a going concern. So if you transfer business as a going concern, the tax law enables you to not incur, VAT in the sense that, so the tax law takes away the VAT burden by exempting it under paragraph K of the second schedule to the VAT Act. But the transfer, must comply with conditions that were set out by the Commissioner General in 2008 in a practice note. So that's an important part of the treatment of VAT when considering VAT on transfers of business as a going concern. Again, tax laws enable businesses to survive difficult times by waiving tax liabilities. For example, we have blanket waivers to taxpayers usually who have paid their principal tax liabilities. We had one in 2017 and a recent one in 2020 as a result of the COVID pandemic, and there is another one coming out in the amendment of 2023. So these are important tax policies that enable companies to have sustainable cash flows and must be therefore understood as helpful tax policies. Now, again, as we discussed earlier, a tax liability can drive a company or any business into liquidation. And because taxes must be paid on particular timelines. Now, what the tax law also does is it enables taxpayers who are having challenges in paying their taxes on the due date to apply to the Commissioner General for an extension of time within which to pay the tax. And also, when you do this, when you make this application, this may be granted, or the Commissioner can require you to pay your taxes in installments, which really helps you manage your cash flows at that point. It has been a very useful tool to in practice for me and many of my clients, that we are able to get installments, an installment payment plan, and URA is really good to the extent that it usually allows these requests. Of course, there are conditions. They will ask you to have security for A, B, C, D, E, but if your issue is cash flow, then it wouldn't be a problem for you to comply with the requirements that URA is requesting you to have. Another aspect that helps with the cash flow is the ability or granted to the Minister of Finance to remit taxes in whole or in part, where the Commissioner General, the Commissioner informs them that the taxpayers' tax liability is going to be there is a lot of hardship in having the tax paid. There's an impossibility or unlikely, there's an undue difficulty or excessive cost of recovery. So the minister then is granted the powers to remit it, but looked at from the other angle, once it is remitted, that's a good thing for the cash flow of a financially distressed company. So taxation, however, can be a cause in itself of insolvency. Now we talk about the strong arm of URA, strong arm of the law, but URA has a lot of power that can easily lead into insolvency of companies. Now, as stated, taxes payable under any tax law are a debt due to the government. Now, URA therefore has at its disposal a lot of tools to enforce collection of these taxes. Now, URA can seize goods that might affect ability of some businesses. If your business really thrives on having these goods exchanged and moving around, then you would really be doomed if your goods are seized. They also have power to charge immovable property, as we stated. So this can affect a company that is trying to get funding. If your assets are already charged by URA, it could affect you greatly in being able to secure funds. URA also has the power to close your business. They can temporarily close your business until you pay the taxes. They can commence distress proceedings. One of the greatest tools that they enjoy using today is agency notices, freezing your accounts. The equivalent of a garnishee order, but one that is swifter, one that you don't need to go to court to do, to enforce. All they need to do is share it with your bankers, and your bankers will freeze your account and pay the taxes to URA. These measures, if enforced, if URA was not to restrain itself from, invoking enforcement of these measures, in every case where there is an unpaid tax liability, then many businesses would be placed into insolvency. But luckily, URA again is lenient in applying some of these, but of course the agency notes are always running around. Now, another cause for another way in which taxation can force you into, of course, insolvency is the penalties and the interest that are contained in the laws. Tax laws often impose penalties and interest for failure to pay taxes and comply with many obligations, including filing returns, etc. And these penalties are not little penalties at all. They are sometimes humongous. The Income Tax Act imposes an interest at the rate of 2% per month on the amount of unpaid tax from the date when the tax fell due until you make the payment. Now that in itself creates, you have a principal tax, which was a debt to the government you're struggling with. The tax law has imposed an interest of 2% per month. If this is a huge amount, then of course you are in trouble. And in itself, this can really push you down into the insolvency proceedings. And then, of course, the VAT Act requires, for example, that you register for VAT. It imposes a penal tax, double the amount of tax that was payable in the period where you should have, filed the VAT return, applied for registration. Now, if your VAT liability was 100 million, and you will of course pay that, and then you have to pay another 200 million just because you did not file your VAT application, it can tell you how much a problem it would be. So if this applies, and seeing as it is that there are strict liability provisions, then potentially these are provisions that can lead you into, of course, insolvency much faster than a company expected. A person who fails to maintain proper records, for example, in a tax period for VAT purposes, is liable to pay penal tax equal to double the amount of tax payable by the person in the tax period. Now, if you again have a 1 billion tax liability and you don't, of course, it's usually the case that those who are liable to pay heavy taxes, such as 1 billion, will most likely have complied. But imagine why you don't comply and you have 1 billion that has been multiplied by another 1 billion. Your descent into insolvency is only a matter of time. And the same, of course, penalty applies where you make a false or misleading statement to URA. Again, this is in respect of VAT. You're paying double the amount of the tax that was payable. And several other places have so many penalty clauses for failure to keep records, failure to furnish a return. All these create monetary liabilities that are problematic to people. Now, quickly, there is so we're talking about, the next thing I'm going to discuss now is compliance as a mitigating factor to insolvency resulting from taxation. Much of what we talked about before comes from penalties and interest that result from non-compliance with tax laws. So we're saying if we then look into compliance, there's a huge chance that this insolvency that is as a result of taxation can be squarely avoided. Let's go into some of these. Now, we have to avoid circumstances that lead to penal taxes. As seen, these penal taxes are usually not few, they are usually a lot. Now, we then have to apply for registration for the relevant tax heads every time. We have to maintain proper records. We have to ensure that statements and declarations that are made to URA are accurate to the best extent possible. We have to use e-invoices and e-receipts. I will discuss that much in more detail below. And we must furnish our tax returns every time. These in themselves can save a company a whole lot of burden, a financial burden that will arise from otherwise no transaction, but tax liabilities. A critical part of compliance is transfer pricing documentation. Now, every company that has a turnover of 500 million and is engaged in intra-group, inter-party transactions, or that is a multinational organization, is required to prepare and have on record transfer pricing documentation, also sometimes termed as a transfer pricing policy. This document is not required to be submitted with the tax returns. The law requires, however, that a company that falls in that category, you have a turnover 500 million in a given financial year, you have a multinational organization, then you must prepare this documentation and keep them. Two things: they are complicated. Those who prepare them will not charge you little money, but they are important to have, because if the commissioner asks for that transfer pricing documentation, you must provide it within 30 days. If you do not provide it within 30 days, you are mandated to pay a penalty tax of 15 million shillings. Now, a good transfer pricing documentation cannot be prepared within 30 days. If someone prepares for you one, then in 30 days, then someone sitting in URA reviewing it for a minute also will say that this one is not good enough, and it will lead you to further audits. A good transfer pricing documentation must take time. must go through a thorough analysis. It must be informed by enough benchmarking and comparability analysis. For you to do this document properly, you need to do it in time, much before URA asks for it, which means then you must engage professionals that are able to prepare for you transfer pricing documentation and have them in time. Otherwise, then you might suffer the disadvantage of bearing a huge tax liability. In short, every taxpayer that is required to have transfer pricing documentation should endeavor to have these documents prepared before the commissioner sends in a request for these documents. Otherwise, there is a 50 million lurking around and every time. You must implement e-invoicing and e-receipting procedures. Now, taxpayers are required to issue e-invoices or e-receipts or employ electronic physical devices that are linked to centralized invoicing and receipting systems, or a device authenticated by Uganda Revenue Authority. Now, when you don't issue e-invoices and or e-receipts, you are going to be liable to a penal tax to the tax due on the goods or services, or 300 currency points, whichever is higher. Now, this provision was used by URA to force many supermarkets and many businesses to implement the EFRIS system, the electronic invoicing system. And URA at the time raised invoices, penal tax liabilities to many of these businesses. In some cases, coming up with excessive tax liabilities. Imagine if someone was to apply that section and they interpreted it wrongly, then you would be in trouble. If someone says that is in relation to every transaction, and you can imagine you're in the business of a supermarket and therefore you have 1,000 receipts in 1 week, and someone was to multiply that by 300 currency points, it's an impossible amount of tax. You just close it. But there has been a helpful explanation and application of this particular clause 73B2 by the Tax Appeals Tribunal, trying to limit the wrath that URA was trying to throw onto the taxpayers. But that aside, as a taxpayer, you must insist that your suppliers are using EFRIS, because expenses of a person who purchases goods and services from a supplier who is designated to use the invoicing system are only allowable as a deduction if they are supported by e-invoices or receipts. So you don't want to have your tax liabilities upside down because your invoices are not supported by e-invoices and or e-receipts, simply because you engaged with a person who did not provide you an EFRIS. If you want to have these services, these deductions for income tax purposes, then it is imperative that you have with you a evidence that you have invoices and e-receipts. So it's important to insist on your e-invoices. It's important to insist on your e-receipts every time you're engaged with a person mandated to do that. Also, when you have invoiced, when you look at the electronic system now, a person other than a taxable person who purchases goods and services from a taxable person, and you are issued with an electronic receipt or invoice worth 5 million shillings within a period of 30 consecutive days, such a person is entitled to a refund of 5% of the tax paid. So of course, again, you get to take this benefit as a tax person who's as a taxable person, as a person who's not, of course, if you're not a taxable person. For VAT purposes, of course, a taxable person means a person who's registered for VAT. So if you know you don't fall in that category, then you are always entitled to these refunds, and 5% of any of that might be helpful in one way or the other. You then have to ensure you comply with the timelines. Failure to file tax returns within the prescribed timelines is punishable with penalties. Of course, the same applies to a failure to pay the taxes that are as a result of your self-declarations. So the taxes must also be paid within prescribed times, which is the technical time is the due date. Now, when you don't pay within the required time, then you start to incur penalties. Now, this is in addition to your taxes, and this is not good. Now, taxpayers, of course, also have to be able to react to URA's communication, so that if URA was to issue an objection, an additional assessment, then as a taxpayer, you must rush to endeavor to file your objection within the prescribed time, and prescribed time here means 45 days from the notice of assessment. If you don't do that, then you run into troubles. You will have to apply for extension of time from URA. Luckily, again, URA always grants this extension of time when you prove that the delay was caused by some reasonable factors. But a good taxpayer, again, should comply by avoiding that unnecessary delay. Engage with your advisors and then get to the core of this within the prescribed time. And if you're a practitioner, therefore, who is desirous of protecting your client from descending into insolvency because of these tax liabilities, it is prudent that you advise them all the time that we need to file these things in time. We need to object the assessments in time. While they are granted, there are cases where assessments have extension of time have been rejected, and this results into huge tax liabilities. So as a lawyer, as a practitioner, you want to tell your client that I notice the moment you get this kind of communication from URA, as a lawyer, you must be sure you operate within the timelines. You must know that time is of essence in tax matters. It has never been more of essence than in tax matters. And now, that is if you have an additional assessment, and therefore you want to object. Now, URA might reject your objection and issue an objection decision. You then have to run to the tax appeals tribunal within 30 days. Why? After 30 days, that tax liability becomes payable. URA is within its rights to issue agency notices, and then you will run to the tribunal. You have to apply for extension of time. You then have to file an application to arrest the enforcement measures. And to do that, you need a temporary injunction. Of course, the law is that to have a temporary injunction, you must have the main application. But your main application is not in the tribunal because you don't have the audience at the time, and then you are in a very complicated situation. And depending on the amount of taxes, and remember, if you if you appeal to the tribunal, you pay 30% of the tax in dispute, of the tax assessed. Now, if you don't do that, then the entire 100% of the tax assessed or in dispute is taken by URA by issuing agency notices. And then you are in a rush hour trying to file agency notices, trying to fix an application for extension of time, and you need a lot of luck to pull that off within the timelines. So instead of leaving it to luck, you want to be a practitioner. You want to be a lawyer who's insisting on having things done within time, and that is the advice that you should be making sure your clients go with in very clear terms. You need to seek certainty. Many of these tax circumstances, tax interpretation and application of tax statutes leads to uncertainties. And that makes it prudent that you apply for a private ruling from URA at all times, whenever you find that your tax liability, your exposure is not certain. This enables you to have certainty in respect to your taxes. Now, in the cases of transfer pricing, it is safe that you pursue an advance pricing agreement with URA. An advance pricing agreement is an agreement between a taxpayer, of course a taxpayer that is subject to transfer pricing regulations, and URA. It majorly is used to establish the methodology that will be used for transfer pricing purposes for a particular period of time. And if you don't have this APA, what you then have is an unending tax liability that might result from URA using a different method from the one you are using. Transfer pricing has majorly 5 methods for ascertaining the prices that should have been paid. These 5 methods can yield different results in terms of the amounts of tax payable, which makes it important that every time you have to look at the methodology that is used to avoid the uncertainty that is related to this. You then engage URA and get an advance pricing agreement. Why am I mentioning this? I have done my research as of 2021. As of 2021, January 2021, there was not more than 2 applications for advance pricing agreements with the URA. This is a regime that was brought in 2011, and we don't have many APAs, which means all these people subject to transfer pricing regulations are operating in chaotic situations and under an exposure from huge tax bills. Now, as advocates, as practitioners, therefore, we should be able to increase the uptake of APAs and encouraging our clients to consider pursuing transfer pricing agreements with the URA. They're usually for a period of 5 years, but you can negotiate. Of course, it's an agreement, so you could negotiate way above that period, and even work. The agreement could even operate retrospectively. So if you don't do that, then any time URA is going to come with a different methodology that imposes a heavy burden of taxes on your client, and the next thing you know, the client will run into insolvency for rescue. So it's important that as lawyers we increase our uptake of APAs at this particular level. This helps in taxes, because a tax liability arising from a transfer pricing audit should and will most likely never be a small tax bill. It is always heavy, a tax bill. So which also leads us to this, that we need to prioritize tax planning as advisors of several businesses, as advisors of enterprises. We must then be able to advise our clients that URA is a major shareholder in our business operations. It takes up 30% if you're a company. If you are a high net worth individual, up 40%. So you need to have the tax aspects cleared in almost every advice that we are giving out. We have to have a sense of what does this mean for tax purposes. Now, recently in 2023, as recent as it's this month, Uganda has passed the Convention on Mutual Administrative Assistance in Tax Matters Implementation Act. This act imposes reporting obligations on people, and there are consequences for not reporting. For instance, an account holder or a controlling person is mandated to notify the reporting financial institution whenever there is a change in circumstances, including a change in the residence of account holder or controlling person for tax purposes within 30 days from the occurrence of the change. So what happened? And then the reporting financial institution is then mandated to maintain information obtained during the conduct of due diligence for a period of 5 years from the date when the account is closed. When you fail to do this, you are exposed to 10 million as a civil fine and an additional penalty of 400,000 every other day the default continues. Now, this convention therefore is designed to achieve exchange of information between between countries to, of course, monitor tax abuse and tax avoidance practices of multinational companies. And the convention has been here for some time. Uganda signed it a long time ago, but we've just enacted the law that implements the convention. These tell us that we would be better served if, as advisors, as advocates, we looked into compliance as a major tool of avoiding insolvency, because URA is a potential creditor in many ways, and URA's debt comes in many ways, wears many hats. It comes as a tax liability, which in any cases it might be a big one. It also wears a hat of penalties. It also wears a hat of interest. And these, depending on what you have, can be big compared to the revenues of the company. And when URA comes to demand for them, it could as well lead you into insolvency. I think that is the short brief I had. I can now open for questions, if any.
Thank you so much, Mr. Deus. We appreciate you for that presentation. Maybe to recap, I took out some notes that I may need to read back to the audience to see if we captured everything right. The first to note is that Mr. Deus observes that URA is a big player when it comes to taxation, and then that we should not avoid that the URA plays a very big part when it comes to taxes to insolvencies. He asks, how do you balance the interest of URA and then those of the business? We need to always be able to balance the two interests. URA wants taxes, you want to survive. How do you balance that? He goes on to state that the tax regime must always consider the practical aspects of the business in order for it to survive. URA needs a good tax regime to be able to enable a business to survive, but not to kill it, to be able to survive in difficult times. He goes on to say taxes are compulsory. He defines the tax as something which is as a compulsory payment due to the government. He says the tax is imposed by the legislature and is aimed at raising revenue for delivery of public service. He goes on to define insolvency, and he says insolvency needs to be spelled out, properly defined. He says inability to pay debt must be defined. It's still vague in the law, but it should be defined. It's a technical term, he says, that it needs to be clarified within the law. He also says that insolvency must be able to maximize return to creditors. It should allow for ranking of competing claims and distribution of monies. It should be able to preserve the insolvency estate. It should be able to provide a timely and efficient and impartial resolution of insolvency issues. Insolvency always prefers collection, he says, collectivism, he says. It's not something you can do in isolation. It's collective, it involves so many people and needs to be factored in. He says insolvency, when you're doing insolvency, you must understand anti-deprivation rule and then the pari passu rule when you're trying to go into insolvency. Even advisor is reading his book. The book makes references to these points, and some of them are within the book. Please look at the book and read the things inside. He discusses then types of creditors. He says there's unsecured, where they have no charge on the company's properties. He says URA is a preferential creditor in light of sections 12, is it, of the Insolvency Act. It basically refers to section 12 of subsection 4, 5, and 6. And he makes his main focus on section 12, subsection 6, where URA is involved, because some payments as a company gets insolvent are due to URA. He also discusses that when tax, it tells you that taxes that enjoy preferential treatment are those that are in respect to withholding taxes only. And it says if they have to act backwards, it's only up to 1 year, not above that. He says that insolvencies can be misused to avoid taxes, so we should be able to watch out on how we do that. He says that it's important to look into the company's losses and profits, because taxes can also be imposed on your losses. He says we need to look at rollover reliefs. We need to look at extension of time to pay taxes. If you feel you're constrained, talk to URA. They will give you more time to pay taxes. He specifically says that taxation can be a tool, or can cause insolvencies. And his point is URA is a strong person. The strong arm of URA can cause insolvencies. So the examples he gives, penalties and interest. URA tends to impose a tax and a penalty that comes out of that. If you fail to pay tax and the tax is imposed, there's an interest payable. He says that interest and penalty can easily lead to insolvency. So we need to be careful with that. And he says to avoid that kind of situation, we need to comply with URA requirements. One of those, he says, we need to use e-invoices, we need to issue e-receipts, we need to furnish proper records, we need to maintain proper records, he says, and we must always apply for registrations. He says you must have records for transfer pricing, especially if your company falls in that category. He says he advises that you must apply, you must use e-freeze invoices, e-freeze for supplies. You must implement e-receipts. And he says you must comply with timelines of URA, because if you default on that, there will be a penalty due for every default you make. He also says that in case you're struggling, you need to seek interpretations from the taxman. At least continuously get rulings from URA from time to time. He also says that we need to have advanced pricing agreements with URA. And he says there are very few companies having those, but he says it's a good mechanism to avoid eventually closing down. He also says we need to prioritize tax planning. We must comply with due diligences in common receipting standards. I've captured the majority. I hope everything is captured. I will now be going into a Q&A with our speaker. Maybe the first question I'll ask, as I came up with myself, is that recently URSB has listed companies for closure, or shut down 800 companies, and its closure, someone is saying that URA still has a control over those businesses. So I'm wondering, how do you now, what is the implication of these closures, and in light of the URSB procedure, how do you now advise these companies when it comes to their tax obligations? Do they have a duty to pay? Do they have the taxes to pay to URA at this point, or they are closed and they are done, the normal liabilities owing?
It's an interesting question, that one. Two things come up. You have a company that has been deregistered that is going to be deregistered by URA, by URSB. Why? It's going to be deregistered because it has not filed annual returns at the company's house, URSB. Now, that assumes that a company that doesn't file company returns has also not complied with its obligation to file income taxes. It's possible that a company, though most unlikely, that you have, on the one hand, a company that is not complying with URSB obligations, but complying with its taxes. Now, if that happens, you have a quagmire and a conundrum that URA and URSB as governmental bodies have to deal with. Because if I am a tax authority, my desire is that I tax the income of whoever has earned it. Now, this company did not register, it did not comply. Now, taking it out of the registry and therefore cancelling its certificate of registration, strictly speaking, means there is no company. Now, it also means there are no tax liabilities. It raises so many questions. First and foremost, what happens to the money of that company? So I found that unless internally there was a discussion between URSB and URA in respect to which companies were going to be removed and all retained, and the tax liabilities that they had at the time, it's going to cause an actual problem for them, because for as long as the taxpayer, the company, the owners of the company can access the money in their bank and they withdraw it and the company is taken off the record, it's a windfall for the shareholders. So it's a windfall for the shareholders. For tax purposes, it's a catastrophe for URA. So it's one government or agency trying to ruin the good day of another governmental agency. And that again goes to the policy makers, and therefore they have to decide how they will deal with this issue.
Yes, thank you so much. The next question is from Vincent Peter Ture from the chat. He's asking if URA is a secured creditor, how about local governments when it comes to local government taxes? Is it the same treatment or it's different? If URA is a secured creditor, how about local governments when it comes to local government taxes? Is the treatment different or it's still the same like URA tax?
It is first and foremost the fact that the taxes are secured must sit within a particular, like we said, taxation is a creature of statute. 1. 2, the fact that the taxes to the central government are treated preferentially in the section. Again, we limited it to preferential debts. Said withholding taxes are preferential, and then we said in many cases they will line up as an unsecured creditor. We move forward to, but there are instances when the commissioner can apply for the taxes to be treated as secured debt. So the section, the tax procedure code, lays it out so clearly. It says you have the power to charge the immovable property of the other person, and to that extent, it would not apply to the other people. So, because again, I can't stress enough the fact that anything for tax purposes must be within the law. You know, so if the law does not allow them to do that, then it's not possible. And the Tax Procedure Code Act gives that power to the commissioner, and the commissioner is largely interested in.
So they're still locked out.
Yeah.
Yes. The other question is what happens when URA issues an agency notice during receivership? As a receiver or an administrator, can I challenge URA on this?
Yes, it is important that we note that when we descend into insolvency, and insolvency includes, but is not limited to, receivership and administration. When you descend into that place, then URA's right to act as a sole creditor ceases. So URA then is mandated to number one, file its claim, properly put, so that the receiver or administrator takes care of it. They don't have the right to issue agency notices, because you have a tax liability that has arisen within the time of the insolvency, and what the law in that area is clear. And there is a tendency, of course, of some officers in URA, not all of them, but some of them, just doing things and saying if you're going to challenge it, it's okay, you go and challenge it. But the law in that regard is I think very clear that you only enjoy a benefit in this regard. The law doesn't say liquidation, for example. It says when we are in insolvency, you are in this context. So again, in receivership, or in any matter, the taxes, the URA should be acting slowly. If not in fact, but at least in policy, because you, number one, are trying to rescue a business that is in financial distress. If you are an administrator, if you are a receiver, you're trying to, as much as you can, bring this company back to its feet. And just in the middle of that process, you have an agency notice that is affecting your performance. And that should not be acceptable for the purposes of insolvency, because the law is clear. No creditor should enforce collection measures
That stage.
at that. As soon as we descend into insolvency, creditors are barred from enforcing those collection measures, and an agency notice brought within that timeline is erroneous, both in law and contrary to the policy of taxation as a tool to enable businesses to recover. It doesn't serve URA, it doesn't serve the government for companies to be killed, if I may use the word. So it is in the interest of the government that when we are in this period, we freeze our individual recovery mechanisms.
Okay, any other question from the online platform as we conclude this session? Thank you so much, Mr. One more question is coming up. Maybe as we conclude, let me ask these two questions. The first one is regarding the Phoenix company. Is there a time given to directors to incorporate new companies for the same business after the end of liquidation?
That's the good thing. And the reason we say that Phoenix is a bad thing and is a tool you can use to avoid paying taxes is that there is no law that is regulating it at this moment. There is no law in Uganda that bars me from closing company A and opening company B to carry out the business that was carried out by company A. There's no law. I am entitled to wake up tomorrow and open a company that is interested in the business of agricultural processing. And 2 weeks down the road, close it and open another one for the same engagement. The law does not restrict us. What is an issue is how far can I go to using it for tax purposes? Because I am filing it and claiming that I want the tax law to pull down. I want to pull down this company so that I don't pay a tax liability of 400 million, for example. It's the only reason I'm winding up. There's no other thing. I'm winding up as a mechanism of I don't want to pay this tax liability. If I have done that, should the government, for example, react to that? Should it say we shouldn't do it? Yeah. Or should it leave us to do it? Because that's a classic case of fraud, of tax evasion. But can you say that I have committed a crime? The processes were that the company failed to pay its debts. I wound it up because it couldn't pay its creditors, and unfortunately including URA. But as a shareholder, I am a liquid man, so I still can run businesses. And I have a niche in this particular venture, so I have opened another one. So it's an argument you could say you're using in good faith. But also it's an argument that phonetism can be used for bad thing, especially if the company is making profit and then distributes shareholder, or in a particular way the assets end up being taken out by the managers or shareholders. If I extract it from the company, then you as the owner, you as URA, have the problem that we are dealing with a liquidated company, and therefore we have to deal with it in that context. After we have liquidated the company, I'm then also within the law allowed to run businesses. Yeah. But you will notice that in other countries, they seek to disqualify. Other countries aim at disqualifying directors and persons controlling companies that run into liquidation where the liquidation is caused by their behavior. So if I'm looking at the behavior of the directors, if I'm looking at the behavior of the owners of the company, and I see that what they did to this company, what caused this liquidation, was intended to come to that conclusion, then those are kind of directors and owners that you want to disqualify. Because one of the objectives of the insolvency law as currently understood is that we must identify those who caused the financial disasters. We need to know who caused this, and if we know that Deus, as the director of company Y, is the one who was the mastermind of this, and at the end of the day caused a transaction of this nature, then we then have to go ahead and try to regulate them. So at that stage, it would, of course, require further amendments, but as currently contained in the law, it is something that I could easily do.
Yeah, there's no restriction.
Yeah,
it's a gap in the law, you're saying.
It's a gap in the
exploit
law,
it, yeah.
And you can exploit it.
Or should we exploit it?
I wouldn't say should we exploit it, but I mean, the other day I was appearing in a meeting at URA. I had this huge tax liability facing my client, and then I said, if we continue with these tax liabilities, if we continue like this, I'm going to have to wind up this company. Because the tax liability, the company's turnover is 100 million. I have a tax liability of 20 billion. What do you want me to do with it? Certainly there's a problem, and it is for 2 years.
Including penalties and interest.
So there is no amount of, if you have audited financials of a company, and they're saying that the company earned 400 million in the last 3 years, and in your last 2 years you have a tax liability of 800 million. There's a problem, because what I earned in itself is not equivalent, and you're only entitled to 30%. Now I said, unless one of us is lying to the other, there's a problem here. And if your case is not that there is misconduct on the side of the taxpayer, that is, they have not provided you information and etc. That's not your challenge. So that when we argue 400 million, it is not in fact 400 million, it is way above. Then it is not correct that you bring such a tax liability. You have an estate company, you have a hotel business, it is struggling, it's a restaurant, and someone is raising such kind of assessment.
Thank you. The last question is, when it comes to charges on movable property, what happens if the property already has a mortgage encumbrance on it? How then do you deal with that? So
the law says the charge by URA is subject to prior charges on that piece of land. So if the commissioner wrote a notice to the registrar of titles, I think the title of that of the office of that of the holder has changed from registrar of titles. But if the registrar of titles receives a notice and finds that there is another charge, this charge will go there, but it is subject to prior charges. But of course, what that does is it gives you a secured creditor in one way or the other.
Thank you so much, Mr. Deus. We appreciate your time with us. We are happy that you've given us all this time to discuss with us. We hope we shall engage with you as we move on. We know you're very instrumental in this debate. And obviously, we shall look for your book and read more about it. And thank you so much.
I thank you. Thank you.
Yes, thank you, the audience. Our next speaker, who is yet to join in, will be, like we talked of synergies, insolvency is a collectivism effort. So it involves lawyers, it involves accountants, it involves tech experts. Our next session, we'll have an accountant who will be taking us through, the accountant is called Mr. CPA, Ronald Mutumba, will be taking us through reporting and accounting in insolvency proceedings. How then do we become transparent, how are we compliant, and how do we ensure there is stakeholder protection? So in the next maybe 10 minutes, we might go for a break, and then when we resume, we'll be discussing that interesting discussion. Thank you for rollout of finance and accounting functions, and he specializes in financial management, cost and management accounting, taxation at both professional levels, CPA and SCCA, and a postgraduate studies with the Heriot-Watt University MBA program. Mr. Ronald is passionate about insolvency practice in Uganda and has been a provisional administrator and administrator for a number of entities in the country. He has successfully supported a number of entities in winding up of their dormant companies in the country. Mr. Ronald, thank you for gracing our event. We are looking forward to hearing from you and learning a lot of wisdom that you have to share with us. Let's hand over the discussion to Mr. Ronald, and at the end of the session we'll have a Q&A. Please prepare them in case you have them. We shall present them to the speaker. Mr. Ronald, yes, take over.
Thank you very much, and a good afternoon to our audience. Thank you very much for the honor for me to present to this audience of learned ladies and gentlemen. I don't know if myself I'm learned. I am an accountant. Yeah. The topic of my discussion or presentation is reporting and accounting in insolvency proceedings, with a focus on transparency, compliance, and stakeholder protection. Reporting and accounting in insolvency proceedings. My view is insolvency processes require proper reporting and accounting practices. These are essential to maintain trust, safeguard interests, and facilitate a fair distribution of assets. We need to appreciate that whereas it is a remedy for entities to get out of financial distress, unfortunately, when an entity or an individual is experiencing distress, there's a lot of mistrust between that entity or individual and the stakeholders. So reporting and accounting comes in very handy and very critical. So I am to quick start this discussion. What is my view regarding reporting? Reporting may be defined as communicating facts and data through reports and statements to the persons for whom such facts and data are compiled for and collected for. It's very important that the facts and the data speak to one another and it's not simply hearsay. This is very critical in ensuring that we have informed decisions during the process. How about accounting? As an accountant, I have been trained to appreciate that accounting is the process of recording financial transactions undertaken by a person or an entity. This accounting process therefore includes summarizing information, analyzing information, and reporting this information, which is usually in the form of transactions. And the reporting is to oversight agencies, to regulators, tax collection entities, and other stakeholders. So, the Insolvency Act, what does it provide for us in as far as financial reporting and accounting is concerned? Within the Act, there are a series of sections that are very specific on the reporting requirements. For example, Section 21, subsection 1 of the Act, which provides for the court to require a debtor in respect of whom a petition has been presented to file a statement of his or her affairs verified by an affidavit. This is requiring a bankrupt or an individual who is claiming bankruptcy to provide us the facts regarding what are his financial affairs looking like. Then we have Section 22, which provides for a public examination of a debtor, his facts and data to be verified in the public. We have Section 23, which provides for any person who knows or believed to have, who is known or believed to have any property comprised in a debtor's estate, to produce any documents in their possession or control. This is also a requirement of the Act that is seen to it that you are not necessarily fishing, but you are demanding for anyone who there is knowledge that they may have assets of a debtor to produce this information. We have section 29, which requires a trustee to keep in accordance with generally accepted accounting procedures and standards a full account and other records of all receipts, expenditures, and other transactions relating to the bankruptcy, and retain the accounts and records of the bankruptcy for not less than 6 years after the bankruptcy ends, and also permit those accounts and records to be inspected. It's important to note that the requirement is use generally accepted accounting procedures and standards. This is a call out to ensure there is a harmony in the standards that is going to be used in preparing this information, because information is only as reliable as the producer. So the producer has got to be held to a standard, and in our accounting world, the lowest level of the standards is usually these generally accepted accounting procedures. So compliance would therefore not be a challenge for the preparer of the information. Section 66 and 76, which requires a regulator to lay before the prescribed meeting an account of his or her acts and dealings of the conduct of the liquidation during the preceding year. This is a requirement for a liquidator. And also section 67 and 77, which require that as soon as the company is fully liquidated, there should be accountability. The liquidator shall prepare an account of the liquidation, showing how the liquidation was conducted and how the property of the company was disposed of, and call a general meeting of the company to present the account and to give any required explanation. This is accountability to all stakeholders. Section 96, which requires a liquidator to give notice of the liquidation on every invoice, orders for goods, or business letter issued by or on behalf of the company on which the company's name appears, stating after the company's name the words "in liquidation," and otherwise when entering into any transaction or issuing any document by or on behalf of the company. This provision is a signal, is a requirement for any liquidator to notify or to bring to the knowledge of anyone dealing with an entity that is in liquidation to be aware that the entity is not a going concern. You are taking on more risk than is the norm by dealing with this entity. That's why each of these documents or pieces of paper must have the wording clear that in liquidation. Why? The logic behind business entities is once you are dealing with them in the norm, they are expected to be going concerns. So this is no longer a going concern. Then we have section 102, which requires a liquidator to prepare reports showing the state of the company's affairs, proposals for conducting the liquidation, conduct of the liquidation, and the estimated date of its completion, final reports, and to make the reports available at his or her address for inspection by every non-creditor, shareholder, or contributory. This is accountability also. Whoever needs this information, the information should be readily available. Then we have section 108, which provides for pooling of assets of associated companies. There is a risk that an entity that is experiencing financial distress could try to hide its assets by locating them into the books or premises of associated companies. So this is a provision that is requiring extended transparency. We know, or we must know, who your associates are, and then stakeholders should have access to assets that you have hidden within the associated entities. We have section 110, which places a duty on every present or former director, secretary, or employee of the company to disclose fully and truthfully to the liquidator all the property of the company and the details of the disposal of any property by the company, including property disposed of in the ordinary course of business. Again, this is accountability of those who have been in charge of the entity before it ended up in financial distress. Another section is section 114, which provides for the liquidation of a company to be complete only when the liquidator delivers the official receiver a final report and final accounts of the liquidation and a statement indicating that all known assets have been disclaimed, realized, or distributed, and all proceeds of realization have been distributed, and that in the opinion of the liquidator, the company should be removed from the register. Here we have a situation where the call is for a liquidator to be accountable for how did this process go and how is it ended, how is it ending. And also we have section 116, which provides for a committee of inspection during liquidation. A lot of power is vested into liquidators, but they also need a form of oversight. So the committees of inspection provide for oversight from stakeholders who appoint this committee. When we come into administration, we have section 141, which provides for the general duties of a provision administrator to include: 1, keeping company money separate from other money held by or under the control of the provisional administrator. These monies do not belong to the provisional administrator, so they need to be kept separately. And also the call for the need for the administrator to keep, in accordance with generally accepted accounting procedures and standards, full accounts and other records of all receipts, expenditure, and other transactions related to the company, and retain the accounts and records for not less than 6 years after the administration ends. Again, this is a call for accountability, and accountability will be ongoing even after the administration ends. We have section 144, which requires the provisional administrator to give notice of the provisional administration. Again, like was the case of the liquidator, once the company is in administration, it is experiencing financial distress. So you, the administrator, provisional administrator, you have a duty that whoever is engaging with the company in any transaction should engage with documented knowledge that the company is in administration, is experiencing financial distress. We have section 147, which requires a provisional administrator's proposals to include a copy of a report by the provisional administrator about the company's business property, affairs, and financial circumstances in the notice issued. This is very important to guide those in attendance and in receipt of your proposals at the initial meetings, to know what is the basis of your proposals, what is the state of the affairs of the company as far as its assets and liabilities are concerned. Then we have section 180, which requires a receiver to keep all money related to the property in receivership, separate from other money received in the course of, but not relating to the receivership, and separate from other money held by or under the control of the receiver, and to keep, in accordance with generally accepted accounting procedures and standards, full accounts and other records of all receipts, expenditures, and other transactions of the company. And, important, retain the accounts and records of the company for not less than 6 years after the receivership has ended. This is a call for transparency, a call for accountability. Then we have got section 189, which prescribes the information the receiver should include in the various reports, the minimum information that he must be accountable for. Ladies and gentlemen, it's also important to note that we have section 256, which requires public notices of any matter to be in the Gazette by inserting the notices of the matter in at least one issue of the Gazette, and also in at least one issue of a newspaper of wide circulation in Uganda in the official knowledge. I take note that the Gazette is an official and authentic legal public information, to the extent that if anything is published in the Gazette, it can be taken that the public is duly informed about the matter contained in therein. So, transparency in information is also very critical as required by this section. So, those that should have been recipients of information cannot wake up and claim that they are not aware of the information if it is in the Gazette. The same applies for a newspaper of wide circulation in Uganda in the official language. Since the newspaper is of wide circulation, the expectation is everyone should have access to it. If you're running business affairs, you have a duty to be informed, and especially to be informed in the official knowledge. So, ladies and gentlemen, what do these provisions strike to achieve? These provisions aim to ensure that there is transparency and accountability in the financial reporting and accounting processes during insolvency proceedings in Uganda, because this act provides for insolvency proceedings in Uganda. Insolvency practitioners and other relevant parties are therefore expected to comply with these requirements to protect the interests of stakeholders and facilitate a fair and orderly resolution of insolvency cases. Insolvency proceedings should be a remedy. So it's very important that insolvency practitioners comply with these requirements to ensure that the insolvency case was a remedy for the entity and its stakeholders. Suffice is to say, therefore, that the above listed reporting and accounting requirements play crucial roles in ensuring transparency, compliance, and stakeholder protection in insolvency proceedings, including the following key areas. When we speak transparency, the provisions are helping us achieve the following. 1. Transparent financial reporting. This is essential in insolvency proceedings. Accurate and timely reporting of the insolvent entity's financial status helps stakeholders understand the extent of the financial distress and the available assets for distribution. Providing information that is not accurate will not be useful to the users of the information. Same applies to providing information in an untimely manner is also not useful, because the information will be delivered after the decision has been taken. The second is transparent disclosure of information. This enables stakeholders such as creditors, shareholders, and employees to access relevant information regarding the insolvency process, especially regular updates on the status of the proceedings, asset valuations, and the overall financial health of the entity. We will have noted that the Act provides for a number of meetings that must be held and when they must be held. This is to ensure that there is transparency in disclosure of information to stakeholders during those meetings. Open and regular communication with stakeholders also ensures that the stakeholders are kept informed about the progress of the insolvency proceedings, the actions taken by the insolvency practitioner, and any significant developments. This is the key role played by reporting. Preparation and submission of reports is critical in ensuring open and regular communication. Compliance. Compliance is critical in ensuring there is adherence to regulations. Adherence to regulations is a critical element in insolvency proceedings, which proceedings are subject to specific laws and regulations that govern the process. The insolvency practitioner must therefore always comply with those laws and act in accordance with their fiduciary duties as a professional. Speaking compliance again, continuous reviews of the insolvency practitioner's actions, proposals, and decisions help ensure compliance with legal requirements and prevent any misconduct. It is important that compliance must not only take place, but it must also be seen to take place. And this is through the continuous reviews. Then also, insolvency practitioners must therefore act ethically and impartially throughout the process. It's important that they are seen to avoid conflict of interests and ensuring fairness in dealing with all stakeholders. During insolvency proceedings, most, if not all, the stakeholders have suffered some damage or they are exposed to damage, then there should be fairness in the extent of damage that each of them is exposed to. Stakeholder protection. There should be fair distribution of assets. Proper accounting and reporting are essential to determine the value of assets and distribute them fairly among creditors according to their priority and legal entitlements. This is clearly provided for by the ranking of distribution of assets as provided for within the Act. Stakeholder protection involves also prevention of fraud. Transparent reporting helps identify and prevent fraudulent activities that could jeopardize the interests of stakeholders. Employee protection. In insolvency, employees may be affected by layoffs or job losses. Transparent reporting ensures that employee rights such as severance pay and outstanding wages are protected. The framers of the Act, in their wisdom, as is the case across most jurisdictions, have provided for employee protection by ensuring employees are part of the preferential creditors. Then we have the rights of other creditors. Creditors have the right to be informed about the financial position of the insolvent entity and the progress of the insolvency proceedings to make informed decisions regarding their claims. So, in conclusion, insolvency practitioners should follow established reporting standards and accounting practices and must be aware that they are subject to oversight by regulatory authorities. The purpose of this is to ensure that the insolvency process is conducted transparently, fairly, and in a way that protects the interests of all stakeholders involved. Ladies and gentlemen, those are my 2 cents on the importance of transparency, the importance of compliance, and the importance of reporting in the insolvency process. Back to you, our moderator.
Thank you very much, the presenter, Mr. CPA Ronald. We appreciate you for those insights. We will go into a Q&A, but I'll try to, as well as I've been doing, I'll give a recap before we now go into the Q&A session. And the recap will be, I would like to highlight some of the things you've mentioned. And the first one to note is that you've defined reporting and accounting, and you're saying reporting is important to maintain trust. It's important to safeguard interest and facilitate a fair distribution of assets. You've defined reporting to involve communicating of facts and data. You said reporting, accounting involves summarizing, analyzing, and reporting transactions as they should be clearly given. You refer to the laws. Your sections you refer to are within the Insolvency Act. You cited sections 21(1), sections 22, 23, 29, 66, 67, 76, 77, 102, 108, 110, 114, 116, 141, 144, 147, 180, 189, and 256 as a legal framework for reporting in insolvency proceedings. You mentioned that insolvency proceedings require an oversight committee for liquidation. And of course, the question will come up, and the question I will ask later will be, is it practical? Does it happen? Does it even happen in practice? But yes, as I recap, the other issue was transparency in information is critical. The provisions you referred to, you said in summary, they ensure transparency and accountability in financial reporting. You mentioned that insolvency proceedings should always be a remedy, not an escape route. And you say insolvency transparency implies transparent financial reporting. Transparency also involves disclosure of information. It involves open and regular communication through publication of reports, and you mentioned the gazettes, newspapers of wide circulation. And in English, you mentioned that transparency also requires compliance, and compliance means you must adhere to the laws and legal requirements within Uganda. You must continuously review. You must act ethically and impartially through the process in order to avoid conflicts of interest, be fair, be balanced. You also mentioned that that we need to. The other thing you mentioned is that you discussed stakeholder protection. Earlier on, Mr. Andrew Mnanura discussed for us widely, in detail, who the stakeholders are. And so, and he mentioned them to include the employees, the government, URA, among others. So, in your discussion, you're saying that as you're doing compliance, you must protect stakeholders. And to do this, you said you must ensure that there is fair asset distribution. You must try to prevent fraud. You should try to protect employees. You should protect the rights of creditors. So as we go into the Q&A, that's a recap I've given. The first question I would like to ask, if we hinted, is that the oversight committees, when it comes to liquidation, does it happen? Is it practical? Or is it just something that the law is providing for but can't be enforced? What do you say about that?
Thank you very much. Inspection committees in the case of liquidation, is it practical? Let's look at the three different categories of liquidation we will have. We have the case of members' voluntary liquidation. That usually applies for situations where there is actually harmony and agreement by all the members. So in such a case, there is really no need for the inspection committee. Yeah? But where the liquidation has been triggered by the creditors, where the creditors liquidation, in that case, the creditors have got a bigger risk profile, and there is bound to be a lot of mistrust. So you, the insolvency practitioner, you need to look at the spirit behind the call for the committee of inspection. If you don't proceed with having a committee of inspection, you are going to build mistrust, additional mistrust, because there is already mistrust. So the few incidents where I have been involved in liquidation, that is other than the voluntary liquidation, I have put in place committees of inspection, and they have come in to be very handy, because it also gives the creditors who have appointed this committee a sense of belonging, a sense of being part of the decision making. Yeah. So to answer you, yes, it is practical and it is very important.
Who then constitutes the committee? Where do you get the parties to take part in the committees? Are they shareholders? Are they creditors? How would you get them?
By the time the company gets into this financial distress, there is one group of stakeholders whose expertise is now in jeopardy: the shareholders and the directors. Okay? That is why the company is being handed over to you, the professional. So the committee of inspection ideally should be is composed of representatives of the creditors. Yeah, it is their interests that are majorly at stake.
Okay, thank you. The second question is, if the entity is under liquidation, how is the going concern concept applied?
The moment the entity chooses to go into liquidation, or is compelled to go into liquidation, then definitely it's no longer a going concern. A going concern from my accounting background status is there is expectation that the entity can remain in existence and operate normally for the foreseeable future. So liquidation alone is a decision of saying, let the entity cease operating and we share its assets. Now, when an entity was acquiring assets, the purpose of acquiring assets is not for them to be disposed of. The purpose was to generate resources to ensure business continuity. So by going into liquidation, you have defeated this purpose. So you are no longer a going concern.
Do you then continue reporting, or you don't? Do you have to continue reporting at that stage?
Once the entity goes into liquidation, then its reporting falls within the requirements of the Insolvency Act. Yeah. So the spirit behind the law, my understanding is, the reason why you give public notices is so that all stakeholders who would have required your reports in their decision making to know that the entity is no longer a going concern.
Okay. Thank you so much. Any other question from the group? Yes, there's a question from Bita Ture. He's asking, thank you, Mr. Ronald, for your lecture. From explanations, I've developed the perception that a good lawyer ought to be a good accountant, and reverse. Is this therefore to advise that they both should be professionals in accounting and lawyers, or you have to separate those? Should I be a lawyer and an accountant at the same time?
Thank you, Bitature. This is an interesting one. And, society usually speaks for itself to point out a development that is critical. I have a number of colleagues who started their professional journey by qualifying as accountants and even going ahead to practice as accountants. But along the way, they picked up the importance of also being the lawyer.
Yes.
Yeah. So we have a number of them who are both lawyers and accountants. Just like I have a number of colleagues I know who started their journey as lawyers and eventually they end up joining us as accountants. So developments around us are showing that a good lawyer might also have to be a good accountant. Myself, I'm not a lawyer. And how do I go about this? I've also found it very important that lawyers and accountants need to collaborate. Yeah. So every assignment that I have been tasked as an insolvency practitioner has always involved a lawyer. Yeah. Especially for administration. Yeah. For voluntary liquidation, there might not be need for a lawyer because that's basically paper processing. And not to mention that most of the assignments that I have been engaged in, I have been contacted by a lawyer on behalf of their clients, and the lawyer continues to support me in the process. So, yes, it is important for an accountant to either collaborate with a lawyer or become a lawyer, just like it's important for a lawyer to collaborate with an accountant, all become also an accountant. That's my view.
Okay, maybe also to note that in the previous sessions like yesterday, it was a theme all through that you need to collaborate. You cannot be a jack of all trades. A lawyer can choose to do his legal work, let an accountant do the accounting part. And I said we need to explore synergies. Let's have lawyers on the team, let's have accountants, let's have tech experts, let's have maybe hackers, white hackers to investigate. Let's have investigators as well. So maybe to answer Vincent, it's important to know the accounting, but let someone else do the work. At least just know that, so avoid, just know what he's talking about so you don't get confused by his discussion. Yes, so it's important to specialize and also important to collaborate. Maybe do you have closing remarks as we conclude this discussion?
Thank you. My closing remarks is definitely to thank Legomac for giving me this opportunity to present to the learned friends. Yeah, there's a lot to learn from one another, and I think this is also critical for the insolvency practice in our country, for it to be mainstreamed out there as a remedy to business challenges and not necessarily an escape route. Other than that, and also to thank the audience for listening in and sharing those views that you asked about. Thank you.
Thank you so much.
Yeah.
Yes, we hope that in the course of these 2 days we've been able to impart knowledge in the team and the audience on the online. We've tried to deliver, and we hope that you've learned something and you're not the same as it was before. You've learned something new from Mr. Mulumba and the rest of the presenters who have been there the previous days. We're now inviting the cluster head, Mr. Keke Karamaji, to come and give us closing remarks as we wrap up this session, this 2-day session. And thank you for being with us for these 2 days and being patient with us. We look forward to seeing you again when you convene to have another session. Mr. Keke, you're welcome. The floor is yours.
Thank you, Joel. Good afternoon to you all. I'd like to thank you, dear participants, for being with us this far, coming to the end. I'd like to particularly thank those that have been with us the last 2 days. Thank you, and thank you very much. We hope that you've learned something, and that you've been able to take more interest, and that you will continue to use this experience in your practice. I would like to thank the presenters for taking their time to share their experiences with us, for taking their time to prepare these presentations. I particularly note that we seem to have moved up a notch or two this time. We have got presenters from abroad, Nigeria. We had a presenter from Nigeria, from Kenya, and someone based in Dubai, so that we can have a broader perspective. And I hope we've all seen that insolvency is a growing subject. We have, in many ways, similar problems. So we shouldn't feel absolutely left out. We shouldn't feel left out from by the other countries. We have common problems, and in a way, we are all in the village together. With the growth of commerce, we're all part of the global village. So we must coordinate more in finding solutions for our clients. This time we've also, dealt with the kind of broader subjects. Let's talk about cryptocurrency. Let's talk about the cases that are coming out of there in the UK courts. We've talked about taxation. So we've moved away. We've also talked about, the experiences that are coming out of live cases. So we moved away from, explaining how the law works to finding faults and finding the challenges that we may face in our practice and see how to navigate them. So in that spirit, I would like to thank the law firms, the lawyers that have, recommended, administration and other modes of rescue to their clients, have been brave to navigate these somewhat uncharted waters and given us experiences to learn from. I encourage all those that are still doubtful to give it a try, so that then we can meet at fora like this, to share experiences and perspectives. So I encourage you to do that. Let's not be shy. I would like to use the words of a judge I met many years ago, Justice Norris, Lester Norris, who always charged insolvency practitioners to be brave, be bold, try out something new. We're all looking for answers. And at the end of the day, let's discuss it, let's critique it, and we'll learn and live off wiser. I'd like to thank the organizers, Uganda Law Society, for putting all this together. Thank you very much. I'd like to single out, Simon Tegeka and Doreen. It's been a pleasure working with you. Please organize another of this very, very, very soon. Finally, I'd like to thank Rita Birungi and Paul Kasami, who have been working with us behind the scenes to put this together, putting the topics, identifying the speakers, and so on. Thank you very much, Paul and Rita. Then I'd like to thank you, Joel.
Thank you.
You look good. Thank you. Thank you so much. So with those few remarks, really, there's nothing else to say that thank you. I feel very honored to have the powers of the President of Law Society to say goodbye, and this meeting is closed. Okay, thank you very much.
Thank you, sir.
Well done. Thank you.